even after putting in those inquiries or sending emails, you are not receiving the appropriate answer, the best thing, you can also get the info pass. Info pass, go to the officer, call the immigration, keep on doing it. This is a repetition of the process. This is the bad part about this. That it's not that you will put in one email or you will put in one inquiry and then you sit on it and then you wait and they don't respond to you within 60 to 90 days. Or 45, they have time period for inquiry, for giving the answers to the inquiries. Different kind of petitions, different timeline when they will be answering. But if you will put in an e-inquiry, I assure you, they will pull out your file and they will look into it and give you an answer. So your email should be accurate, what you enter over there, your information, and then the petitioners and the beneficiaries' information on the case number should be right. Any other question you have? Oh, yes, sir.
So, my name is Atif. So I have two basic questions. One is that. So I have two questions. One is that if someone gets the conditional green card on the family based marriage, and when he's gonna get the remove the condition after how long? After 2 years, I heard. But I also heard that he should apply before the time period and before 3 months. Can you clear that? And if in these 2 years, if they get separated or get divorced, so how many chances are there that it is going to affect the green card, the applicant?
Okay, so you have two questions. I will answer the first question first. So your first question is that what is the timeline when you are eligible to file for the removal of condition once you get a conditional green card? Usually when you get a conditional green card, 3 months prior to the 2 years expiration, you will receive the letter from immigration that you need to now, you are eligible to file for the removal of condition application, which is I-751. You file that application. If you, husband and wife, they are together, they will be filing the joint petition for that. If, unfortunately, they are not together by that time, then there is an option available that is called the waiver. So you will sign it because both of the petitioner and the beneficiary are not signing, or both of the petitioners are not signing that. So one signatures can be waived along with the complete documentation showing the reason and proving the reason that why is that, why it happened, why both names are not there, if there is a separation or a divorce. Based on that, the supporting documents should be provided.
You have
yes.
To wait the letter from the USCIS until you cannot file it.
No, there is no restriction, but that's a process, they will send you. But still you can, it's not that you have to file your application, that is the deadline, once the 3 months are there, like before the 3 months. Even you can, if before the 2 years time period, you are supposed to file for the removal of the condition application, but it's better to follow the 3 months rule and start processing your 90 days application.
Okay, unfortunately, that's all the time we have for Q&A. We need to move on to the next speaker, since we have a hard deadline of 4:15. Ms. Butt, can you pass out your office phone number, and maybe some of these people who have questions can call you?
Yes, sure. I will be here to answer some of the questions afterwards also, but my number is 281-870-1300. If you have any questions, any concerns, you can still call and mention that you are calling with regards to this seminar and get an answer. Thank you. And business cards are also there. Thank you.
Thank you, Ms. Butt. Now, the next speaker is going to be Sana Abid. She's going to be talking about uncontested divorces. Sana is an attorney that practices family and criminal defense in Paris and Fort Bend County, as well as surrounding counties. She has a JD from Michigan State University, and she has been a member of the Texas Bar since 2014. Sana.
Assalamualaikum, everybody. Okay, too close. Today I'm going to talk about uncontested divorces. I did do a little PowerPoint. Hopefully it works. I'm not sure if it will. Fire, are you ready? Okay, next slide. So, what is an uncontested divorce? I get a lot of phone calls from people saying, we've agreed to everything, we need an uncontested divorce. But most of the time, it is not an uncontested divorce. They're still fighting over things. So an uncontested divorce means you and your spouse agree on all matters, such as who's going to be the conservator of the children, who's going to be for the non-custodial parent, what are the visitation schedules going to be looking like? Is there a geographic limitation on whether the custodial parent can move anywhere within the United States, within Texas, or even within a specific county? Child support, that's a major one. Who's going to be covering health insurance for the children? And if there is any community property, how is that property going to be divided? Next slide, please. So how are you going to initiate an uncontested divorce? First of all, you have to file a petition. That costs about $300 in Harris County and about $310 in Fort Bend. You have to determine which county you're eligible to be filing this petition in. If you're living in a specific county for the past 90 days and a resident of Texas for the past 6 months, that's the county you will be filing the petition in. If you're doing it pro se, which means without a lawyer, you can go and get helpful forms online at texaslawhelp.org. They have 2 types of divorce forms, one with children and one if you do not have any children, you would be filling out that form. Next slide, please. Do we have to serve the respondent? The respondent is the person who is not the petitioner, okay? Now, in an uncontested divorce, if everything is agreed upon, the respondent does not need to be formally served because they can file something called a waiver of service. A waiver of service means that the respondent is saying, I don't need a process server or a constable to come and serve me about the notice of the petition at my place of residence or at my place of business. And that waiver of service can again be found on the texaslawhelp.org website. And this has to be filed at least 1 day after the divorce petition has been filed. It has to be signed and notarized by the respondent. A lot of courts, actually most courts, have requirements for mediation in contested divorces. But if you truly have an uncontested divorce, which means you have agreed upon every single thing, then there is no mediation requirement, and you can proceed to the final order, to the drafting of the final order. Some courts also want parenting classes done. Especially in Fort Bend County, I've noticed a lot of courts require that a parenting class has been done by both parents, and it has to be filed with the court before your divorce can be completed. You can go online on whichever court you've been assigned to on their website and check its rules and procedures to check if there is a parenting class required. If there is, then online they also have lists of accepted parenting courses, which you can do online or in person, whatever is convenient for you. And like I said, that has to be filed before the divorce is proven up. So after a divorce is filed, even though you have agreed upon everything, Texas law states that you need to have a 60-day waiting period. That's called a cooling off period, because you might change your mind. You and your spouse may decide, okay, we don't want to go ahead with it. So the law allows you, a 60-day time period where you can really come to terms with whatever your agreements are, whether you want to go ahead with the decision or not. And in the meantime, if you're pro se and you've agreed upon everything, you can go ahead and draft a final order with all the agreements that you and your spouse have agreed upon. And a sample order can again be found on texaslawhelp.org. That is a very good website for pro se litigants. And both you and your spouse will need to read through the order and execute it. The last step is, or one of the last steps is proving up a divorce. Now, after the divorce decree has been signed and the 60-day period has passed, you as a petitioner, have to go to court to prove up the divorce. Proving up the divorce is a legal term. Let me explain that a little bit. It means that you're telling the court that you have met all the requirements, the jurisdictional requirements, which means that you have lived in this county, you have lived in the state, and you're eligible to file here, and that everything in the divorce decree has been agreed upon by both you and your spouse, and you're asking the court to approve this agreement and grant you and your spouse a divorce. Mostly your spouse, the respondent, does not need to appear for the prove-up if they have signed the decree, but they can appear if they want to. They are entitled to notice of the prove-up. And once the prove-up is done and the court has granted the divorce, the judge has signed on that order, that means now your divorce is final. So what are the final steps after the divorce has been signed by the judge? You have to get a certified copy of your divorce decree. That's $1 per page, and it's available on the district clerk's website, right, whether it's Fort Bend or Harris. If you have children and there has been a child support order, you need to contact the Attorney General's office to set up the child support for the custodial parent. And also, if there is community property and you have agreed on in your divorce decree how that community property needs to be divided, well, now you need to go ahead and divide that community property as agreed upon. Some things to remember when you're going through a divorce. Once divorce is finalized, any property division in a divorce decree cannot be modified. It cannot be changed. So you need to be sure when you're agreeing to something regarding property division, whether that is something that you are 100% comfortable with or not. Secondly, child support cannot be changed for 3 years unless there is a material and substantial change in circumstances since the order was signed. So again, everything, people might agree on a higher child support than the standard guideline. Well, 2 months later, they can't come and say, oh, we don't want to pay that because it's not guideline, unless they can show a substantial, change in their job or something. So you really need to think about those things. Thirdly, conservatorship and visitation. Again, that cannot be changed for 1 year unless you show a substantial and material change in the well-being of the child. So that's what I had. If any of you have any questions, yes.
In case of separation only, in case of separation, what is the child support, like can anyone claim child support?
Yes, you can go to the Attorney General's office and they will open up a case for you and they can look at, your husband, how much he's earning, how much he's making, and they can allot a standard guideline, which is 20% for one child, 25% for two, 30 for three, and 4 or more is 35 of their net income.
When you file a divorce, petition for divorce, what are the requirements, what are the documents required need to be attached with the petition? Is there any, or you just need to fill out the petition form or this?
Yeah, there is no actual requirement that needs to be attached. You need to fill out the petition, whatever questions. If you go on the Texas law org that I have on the paper there, if you have children, you can look at the standard forms. They have instructions and toolkits, and you can just follow the instructions on how to answer the questions. And if you need to consult with a lawyer, you can do that too. You don't really need to attach any documents. The petition itself is enough.
There was a question on that side.
As you explained, the process of divorce is very simple, but why does it drag and gets into a filthy and very dirty process and long divorces?
Well, I only explained the uncontested divorces, which means that everything has been agreed upon by both the husband and wife. What scenario you're talking about is a contested divorce where they're fighting over things. My topic was only simple uncontested divorces where the spouses have already agreed upon every single thing that I mentioned in my first slide. The children, child support, visitation, community property, how it's going to be divided. If you're fighting over anything, then it becomes a contested divorce. You need to go for either mediation, you probably need to consult an attorney to see how they can help you.
Any questions on this side?
I have one question. Usually, during the divorce cases, the husband hide his property and assets, and we know that it is in somebody's name, but it is there. So what should be done in that scenario?
Again, that when you're alleging waste of community property or fraud on the community property, that's basically fraud if they're putting it in someone's name. That becomes a highly contested divorce. It's not an uncontested divorce. At that point, you would definitely need an attorney to help you. They would need to conduct discovery, see what's been done. They would need to trace back to the marital assets. It's a complex, that becomes a complicated situation. But my topic today was just a simple, uncontested divorce.
Thank you.
Ma'am, the same thing happens in separation also, or it's just closure? I'm sorry. The same thing happens in separation also, or it's just divorce thing? That
When you're talking about separation, are you saying that the partners are just living separately, but they intend to divorce, or?
Yes, when they intend to divorce, but they are not they have not filed for divorce. But I'm asking for the child support. If someone is hiding their properties or their income, what effect it will be on child support?
Well, like I said, the property doesn't really matter for child support, it's the income.
Yeah.
If they're, saying they earn less than they actually earn, so you need to, when you contact the Attorney General's office, you need to let them know, why you believe that. If you have any evidence to prove that they earn more, then there would need to be an investigation on that issue. And when you go ahead with the divorce, that's when you would look at the property, what they're hiding, what's going on with that.
Thank you.
You're welcome.
Just a quick question regarding, you said you should not sign the final decree if you're not agreeing, or if you don't feel comfortable.
Correct.
What if the judge made the mistake and you signed it?
What do you mean, what if the judge made a mistake?
Final decree, you looked at it and there's a mistake in it, and the judge basically called for it and you signed it.
So there was something that you did not agree to
Yeah.
in the decree and you signed it?
Right, I ended up signing it, and what do I do now? Like after?
Okay, if you have signed, is it because you didn't read through it correctly, or like is it your fault that you didn't read
You
through
don't get a
it?
chance, like when you go to the judge, this is what it is, they're just gonna give it to you, you sign and you walk out, final decree, very given.
In an ideal situation, you would always have the chance to look over the decree, and the judges give people chances. However, if it has been signed because you were defrauded by somebody, you can probably appeal and ask for a modification of the decree and ask for it to be voided. But usually you would have to read through the decree correctly, and judges give you that time. And when you're signing, you're accepting whatever is in the decree.
So the judge would not really agree on his mistake, that's the problem. With the fourth thing, I don't know, but Zori County, the judge is the only one, he's the guy over there. If he makes a mistake, nobody can touch him. That's what happened to my case.
There is a motion called no punctum. It's a legal
Yes,
term,
something like
and
that. You're
sorry?
not aware of it, when you go through the first time, you're not aware of the system and everything, and you end up doing that, and the system is like one-time deal,
I think an attorney would have to look at your specific case to see what can be done.
Can you pass out your office phone number, that way if anybody else has any questions?
Do you all have my printout that I gave? Okay. Well, yeah, it's out in front, it's right here. I have my business cards here, and I'll be handing out also like this stuff if any of you have any questions. Thank you.
Thank you so much. The next attorney who will be talking today is Amir Sadiq. Amir went to law school at the University of Texas. After completing law school, he did a clerkship with Judge Harry E. Hudspeth. I hope I pronounced his name correctly. Federal clerkships are not easy to come by, so kudos to you for doing that. Amir is an attorney with Wilson & Owen, and his primary area of practice is on contract disputes, partnership disputes, and personal injury lawsuits. Today, he's going to talk about personal injury.